compelling, and all, each in their own way, gave equal standing to them for different reasons. Our argument is that none of them are compelling, none of those reasons, and that if you open the door to that, then everybody will have a compelling reason to step into the case, and there'll be no reason to have an original jurisdiction case. The two states can just step over to the side and say, okay, y'all just argue like an ordinary lawsuit. That's basically, and I think it caught the court's attention. We don't know
the Supreme Court's
attention. I don't know what the result will be, but we're certainly encouraged by that. But that's the answer to it, is that I can only ascribe her application of the law, which was incorrect, but I believe she concluded that each of their cases were unique and therefore compelling.
I'd like to emphasize that our friends in North Carolina have been very friendly and cordial. They just haven't let us get to first base on our influence on their decision. And Charles Candy went to the meeting of the, what was it, 30 people on the, what was the name of it? Environmental Management Commission. That is the institution in North Carolina that gives the permits for the interbasin transfers. And when she went up there, she was treated very nicely. They just didn't pay any attention to our arguments. But it was after we got into the case that we learned that this was not the first interbasin transfer that had been allowed. There are several others that this commission has allowed under their state law, and they total up to now, what, 72 million gallons a day. And we don't know how many of them predate the creation of the commission, so there may be others that we don't know of. But North Carolina's attitude is that it's their water, they can use it however they want. Taken to the extreme, that would be they could dam it up and keep it all there if they wanted to, which of course would be a disaster, and they of course would never attempt to do that. But when things get tough, there's no telling what people will do. So that's why we have to protect ourselves now before it gets any worse than it is. Yes, sir.
You know, you mentioned that there were cases like this that were litigated in western states previously. In respect to our position in this case, similar to other states in these kind of battles, what's our outlook for success and probability of time frame that we might be able to get?
On the time frame, with Chief Justice Roberts, we understand that he likes to move these cases along. The last case we had like this with the state of Georgia was not over; it was over the boundary line as it went out from the Savannah River out into the ocean. There are islands and things out there, and of course, mineral wealth beneath the water. That was an issue. And so we wanted the line to extend one way, and they wanted it to extend the other way. That case took either, what, Bob, 12
years.
Took 12 years, cost a lot of money, and it ended up being successful for us. We're told that Chief Justice Roberts likes to move them quickly. Usually it was suggested that this one may be completed within 2 years. With these, that would be probably a world's record for brevity. But with the addition of these interveners, of course, that just stretches it out, so we really don't know. We're in uncharted waters. As to the other types of cases, there have been cases that said, as I mentioned a moment ago, that a river going through states belongs to everybody, and everybody has an equal right to it, although perhaps the proportions are different based on your economic development, your population, and your geography, and your hydrology, and your climate, and all the presence of other rivers, and all that sort of thing. But in those kind of, the fact has been established about the ownership, and no special person, including Duke, owns that river, although Duke appears and has asserted that they do own a part of the river in their pleadings. But we know that the states own the river equally. Now, out west, there's a different kind of law that has been used in those cases, and although they're instructive, they're really not of any precedential value. This is going to be one of first instance. Would one of y'all like to, or Charles like to add to that about how they do it out west?
Well, of course, South Carolina is a riparian state, almost all the states, I believe, are appropriation states.
What's that?
That means that particular amounts of water are owned or appropriated to particular water users, whereas in a riparian state, all of the users are entitled to the use of the water equally. The appropriation states basically sort of dole out ownership of the water, and basically at some point a river becomes appropriated. Now, it's not exactly right to say none of those cases out west are applicable to us. We think there are a couple of good cases that recognize where a river is over-appropriated, so to speak, using the Western term here, over-consumed, shall we say, the Catawba is, then any diversion upriver is going to harm the downriver by definition. And that's what I think our situation is. The Catawba is in such a situation, of course, as Bud Bader knows very well, when there's plenty of water, there's plenty of water, and nobody's got any complaints. If it's raining all the time, and you know the reservoirs are up, and everybody's getting plenty of rain, the Catawba's in good shape. But as soon as the drought begins, then we're in a situation where every drop counts, and those 72 million gallons per day count a lot, and then any other use by North Carolina counts a lot as well, and by the time it gets to South Carolina, we're in a world of hurt, and that's where we are.
Out west, if you go try to find the end of the Colorado River, you'll discover that it dries up before it gets back to the ocean, because they're using up the water out there. Go ahead. Sir.
One question, and this may be for Mr. Cook, but as he was speaking, I understood that there were two, it was a bifurcated case, and that the first hurdle was the one that necessary to establish damages. And
Injury or harm.
Or damage.
Yes.
Yeah. So my question to you would be whether or not there are actions that any of the jurisdictions downstream on the Catawba, whether it's a county or city or others, are there steps that they can take to assist you in this process?
Well, the answer to that is yes. What we are looking for, of course, particularly in times of drought, I don't want to get too much into the case, but in times of drought, whether it be maybe recreational harms or economic harms or environmental harms, if there is evidence of that, that would be very helpful to us. And the further down you go, I guess the less the impact, but that's not necessarily true. So, and I think Water E might be a testament to that, particularly with the phosphorus and that kind of thing. But yes, the answer to that is we are looking for any harms that will help demonstrate the overall harm. Because the Supreme Court says the harm to the state can't be negligible, it can't be nominal, it has to be substantial. And that will be our burden. We brought the suit. So first test is, have we shown by clear and convincing evidence that South Carolina has been harmed substantially by water uses in the Catawba River by North Carolina?
Y'all remember back in the drought a few years ago in the TD, there were pipes going into the river over there from industries along the way that were sticking up. Some of them almost exposed. The water had gone down so far they were about to get where they couldn't take the water out or put anything in the river. The river was so low that their permit, the concentration of the effluent they were putting in was so high compared to the lack of water in the river that they were going to have to shut down or spend millions of dollars to revamp all their cleanup process in order to keep business going. So that's the same kind of information